In just 6 short years, we've seen a dramatic reversal of 4 key constitutional premises upon which national policy had been conducted. First, as we all know, the current administration has justified just about every action it's attempted, whether warrantless NSA surveillance, cruel treatment, or indefinite detention of detainees, or assertions of executive power, with a sweeping theory of unfettered power based on an overbroad reading of the Commander-in-Chief Clause and dicta for the Supreme Court's decision in U.S. versus Curtis Wright Export Corporation. When I was in OLC, the Office of Legal Counsel, we used to call that the Curtis Wright, so I'm right, site. And under Curtis Wright, the President's Article 2 powers are paramount, Congress exercises minimal oversight, government secrecy prevails, and the Solicitor General urges the courts to defer totally to the President. Well, our best response to this anti-constitutional vision is to go back to the future, to follow the path taken by the Supreme Court last year in the Hamdan decision. In that case, all of the justices, not just those in the majority, but all of the justices did not adopt a constitutional framework based on Curtis Wright. They placed the case within the accepted framework of shared institutional power set forth in Justice Jackson's famous concurrence in the Steel seizure case, Youngstown Sheet and Tube. Now, obviously, they differed about the outcomes. Justice Thomas, for example, thought the President's actions were authorized under Youngstown Sheet and Tube. But none of them adopted this dramatically different constitutional framework. A second element, the Bush administration's invoking of the war on terror to create law-free zones, which they called Guantanamo, law-free courts, which they call military commissions, law-free people who they call enemy combatants, and law-free practices, which they call extraordinary rendition, all of which share an exemption from judicial review. In so doing, they've opposed political efforts to incorporate international and foreign law, particularly the Torture Convention and the Geneva Conventions, into the domestic legal framework so as to insulate themselves from charges that they're violating universal human rights norms. But again, in Hamdan, the court rejected this and went back to the future. They rejected the government's claim that Hamdan was a person outside the law, held in an extra-legal zone just because he was in Guantanamo, who could be subjected to the jurisdiction of a non-court, a military commission that didn't look like one authorized by the Uniform Code of Military Justice. And the court treated as binding a universal treaty obligation, Common Article 3 of the Geneva Conventions. Now, shortly after Hamdan, I testified before the Senate Judiciary Committee. One of the senators said to me, "Professor, the terrorists haven't signed Common Article 3. Now, here inside the Beltway, you soon learn that the word professor is not a word of respect. When you hear it, you should think, idiot? Idiot, the terrorists have not signed Common Article 3. And I said to him, Senator, the whales haven't signed the Whaling Convention either. This is not about contract. Common Article 3 is not about them and who they are. It's about us and who we are. As a matter of universal principle, we're obliged to give all detainees basic humane treatment, however despicable they might be. And unlike the government's notion that they can pick and choose when U.S. law can apply and to whom, we promote instead a constitutional vision wherever U.S. officials govern under our public law, then they must accept the constraints of that public law. Now, a third argument, in addition to the Curtis Wright argument, and in addition to the argument that has been made about extra-legal zones, people, persons, commissions, we've heard repeatedly the claim that the executive can infringe on civil liberties without clear legislative authorization, relying on long, broadly worded laws like the Authorization for Use of Military Force Resolution. But again, in Hamdan, the court took us back to the future, rejecting that claim, demanding a clearer statement before the commander-in-chief could try a suspected alien terrorist before a military commission that had not been authorized by statute. As Justice Breyer put it, the court's conclusion rests ultimately on a single ground: Congress has not issued the executive a blank check in the AUMF. And fourth, and finally, as David Cole has noted, the Bush administration has dramatically widened the disparity of treatment between aliens, particularly enemy aliens, and citizens. But in Hamdan, again, the court took us back to the future, because they acknowledged not only do enemy aliens have rights, but more fundamentally that the government can't discriminate against enemy aliens by asserting a dichotomy between law and war. A key element of the Bush administration's strategy in the war on terror has been what I like to call the Tina Turner question, which is when the planes hit the tower, you suddenly say, what's law got to do with it? What's law but a sweet, old-fashioned notion? We're at war. If we're at war, there can be no law. And once war begins, law ends. Well, the Supreme Court rejected that, again, going back to tradition, and said, you know, there has always been a law of war. And when we are in war, a law of war applies. It's not a zone without law. It is a zone in which a law of war applies. Or as Justice Kennedy put it very succinctly in Hamdan, if the military commission at issue is illegal under the law of war, an offender can't be tried by the law of war by that commission. Now, if this has been the Bush administration's four-part constitutional vision, Curtis Wright, human rights double standards, infringement of civil liberties without clear statements, and targeting enemy aliens by claiming to fight a war against them outside the scope of law, then our challenge to that distorted vision should be to return to the traditional framework of what has always guided something I call the National Security Constitution, a traditional framework based on the steel seizure vision of shared power in foreign affairs, human rights universalism, a principle of clear legislative statements, and acknowledgement that under the law of war, even enemy aliens have rights.